Hello everyone, good afternoon. Thanks for joining today's webinar session. So today's webinar session is up on your screen now. Hopefully you can see that. It's COVID-19 employment law considerations, a recap and reminder. Today's presentation is delivered by, we've got Tim Thomas, who's Director of Labour Market and Skills Policy, and Charlotte Haggerstadt, who is legal advisor based in our HR and employment law team. I know we've got lots of people on the webinar today, including lots of members from Make UK partner organisations, so welcome to everyone. Because of the numbers, the lines are on mute, so if you've got any questions, please do fire them through the chat box, which you can see in the corner of your screen right now. I know we've got a bit of time for Q&A at the end, so please feel free to put those questions through to Charlotte and Tim. So without any delay, really, I'll hand over to Charlotte, who's going to take you through the first part of today's presentation.
Thank you, Roger, and thank you everyone for joining. So the topics that Tim and I are going to cover are listed on this slide. I'm going to start by looking at the revised coronavirus job retention scheme, then at how the NHS test and trace scheme might affect you as an employer, moving on to what the new rules on shielders mean for return to the workplace, and Tim's then going to cover quarantine rules and risk assessments. So I'm going to start by looking at the key elements of the revised job retention scheme which apply from tomorrow. It's worth just pointing out that even though the framework for this scheme was announced at the end of May, guidance on how it's going to operate in practice is still being produced. So we've had the first tranche of guidance from HMRC on the 12th of June. There was a new Treasury direction published last Friday, but we are still expecting more updates to guidance during July. You'll be aware that a key feature of the revised scheme is the tapering of the amount of grant that you'll be able to claim back from HMRC. Under the revised scheme, employers themselves will continue to receive 80% of normal pay, subject to the normal monthly cap of £2,500, and that's until the end of October. But from the 1st of August, the cost to you as the employer of keeping employees on furlough is going to increase. First, you're going to become responsible for employer NICs and pension contributions, and that's from the 1st of August. And then from September, you're also going to have to fund an increasing percentage of the furlough pay as well. So from the 1st of September, you'll be responsible for 10% of normal wages subject to the cap, so you can claim back 70% of normal pay. And then during October, you'll be responsible for 20% of the employee's normal wages, so you can essentially claim back 60% of normal pay subject to the cap. So in other words, the cost of keeping employees on furlough is set to increase from the 1st of August. So which employees will you be able to furlough under the new scheme? Now, one of the main changes in how the scheme is going to work from tomorrow is that there's going to be a restriction on who can be furloughed. So essentially, the revised scheme is now closed to new entrants. The last date on which an employee could be furloughed for the first time was the 10th of June. And then there's a slightly more complicated requirement about the number of employees that you can claim for in any claim period. And this can't exceed the maximum number you claim for under any previous claim period under the scheme in its original form. So, for example, if you'd previously submitted 3 claims in, say, March, April and May, and in each of those periods you claim for, say, 30, 20 and 50 employees, the maximum number of employees that you can furlough in a single claim from tomorrow will be 50. And I'm not really expecting this to be all that much of a problem for most employers, particularly if you're just beginning to bring people back from furlough. But for any employers who've been operating a rotational furlough system, there might be more of an issue. And I've certainly talked to some employers who are finding that wanting to switch from rotational furlough to bringing people back, more people back at the same time, part-time, are running into a bit of a problem that they can't quite bring back the numbers on flexible furlough that they'd like to, simply because of the way in the past their claim periods had worked out. So what about employees who've been on maternity leave or military reservists who've been called up and are coming back? Well, luckily there are some exemptions from these maximum limits which enable you to furlough an employee for the first time after the 10th of June if they've returned from statutory family leave, so that's maternity leave, paternity leave, adoption leave and so on, or if they're a reservist who returns to work following a period of mobilisation. And you'll see there's some conditions attached to these exemptions in the 3 bullet points here. So an employee who wished to furlough for the first time must have started their family leave or been mobilised if they're a reservist before the 10th of June, returning from that leave after the 10th of June, and they must have been on your PAYE payroll system before the 19th of March, and you must have previously furloughed other employees for 3 consecutive weeks prior to the 30th of June. And if any of you expect to have employees TUPE'd to you after the 10th of June and going forward, you'll also be glad to know that there's an exemption that allows you to put TUPE'd employees onto furlough, provided they meet certain requirements about having been furloughed for the right amount of time by their old employer before the transfer. This slide now covers flexible furlough. Now, from tomorrow, furloughed employees can come back to work part-time or be re-furloughed on a part-time basis. And we've had a lot of interest from our member companies in using flexible furlough, mainly to bring employees back from full-time furlough, where operations are beginning to get up and running again. But equally, you can use it to reduce the working hours of someone who has already been brought back from furlough into full-time work. So when an employee is on flexible furlough, you're going to be responsible for paying an employee's wages while they're in work. But you can claim a pro rata amount under the revised scheme back from HMRC, and that's for the hours for which the furloughed employee is not working. And the cap, that £2,500 monthly cap, will also be prorated for employees on flexible furlough depending on the amount of hours they're working. The calculations for how much flexible furlough pay you can claim back from HMRC are actually, unfortunately, really quite complicated. And, arguably they've been made more complicated by the recent Treasury direction. But the basic premise is that when you make your claim, you have to submit data on the usual hours that your employee would normally be expected to work in a claim period, as well as information about the actual hours they've worked. But the formulas then differ depending on whether the employee's got fixed or variable hours and whether their pay varies based on the number of hours that they work. And there are lots of worked examples in the HMRC guidance which you can look at, and there is extra guidance in the Treasury direction that I just mentioned. But I think in a lot of cases you're likely to need to take advice from your payroll providers to work out the pay calculations because they're not that straightforward. And you also need to be aware that you shouldn't make a claim until you're sure of the exact number of hours that an employee actually will have worked during the claim period. Lastly, that point on the slide is that there is no longer any minimum furlough period. So the previous requirement for a period of furlough to last for a minimum of 3 consecutive weeks no longer applies for a furlough period which starts on or after the 1st of July. But if a furloughed employee starts a new furlough period before the 1st of July, this furlough period must be for a minimum of 3 consecutive weeks, even if it ends after the 1st of July. So on this slide, I'm going to now look at how you choose who to offer part-time work to during furlough if you've only got work for some employees to do. And the first thing to note here is when you're making decisions about who to be on furlough and who to bring back to work, that equality and discrimination laws will apply in the usual way. And I would say that the main way in which you can reduce the risk of a discrimination claim arising from this is to be really careful not to make assumptions about whether certain groups of employees would want to or be able to return to work. And it's certainly clear from the questions we've had on our helpline that the patterns you might expect aren't necessarily as coming about. For example, don't assume that women with children or older employees or employees who've got underlying health conditions would prefer to stay at home on furlough. And also be careful not to assume that you won't be able to accommodate somebody who's got an underlying health condition safely, because actually there's quite a lot of things that you can do to make sure that that's possible. So as a first step at deciding who to select to bring back to work on flexible furlough, a really good starting point is to think about, obviously, which employees you require, how many employees you require, and what jobs you need them to do. So to really focus in on your operational need. And once you've identified that, I'd say that an easy way of reducing the risk of discriminatory decisions is to ask out of the relevant group of people who wants to return. And this prevents you making the type of assumptions I've just mentioned. Also been finding that it's helped reduce so the sense of unfairness that some employees might otherwise feel, because some employees might prefer to come to work, back to work part-time, top up their pay, whilst others, for all sorts of personal reasons, might prefer to remain at home on full furlough. I mean, obviously, you're going to be quite lucky if this approach results in exactly the right numbers of people wanting to come back in the roles you need. So the approach you take next in fine-tuning the people who are coming back will depend a bit on whether you've got more employees volunteering than you've got jobs for, or the other way around. But if you do have more employees volunteer than you've got jobs for, one thing which I know that some of our members have thought about is considering asking more employees to return part-time, with each of them working fewer hours to spread the work around. Or alternatively, you might want to consider a rotational furlough arrangement, whereby some employees are kept on full furlough while others return to work, and then the groups are switched over. If you still don't have the right number of volunteers, I'd say the safest approach is to conduct an objective selection exercise, a bit like a redundancy exercise. But again, in practice, I think a lot of our members have been finding, when they've been thinking about it, that practical considerations might override this. You know, which employees are actually still able to work and want to work, and you might also want to take into account the sort of longer-term employee relations issues when you're making those decisions. It's not necessarily going to be straightforward. So what do you need to do to agree flexible furlough? Well, the new Treasury direction confirms that if you flexibly furlough employees, you'll need to agree this with the employee or reach a collective agreement with a recognised trade union. And that's not really a surprise, because that's the current case under furloughing full-time. And the bullet points in this slide just list what the Treasury direction expressly says, the agreement that you make with employees about flexible furlough, what that agreement should cover. First of all, it says you should specify the main terms and conditions on which the employee will either do no work or will not work the full amount of their usual hours. But also you need to make sure that this agreement is in place before the beginning of the period of flexible furlough. I think it's quite helpful actually that the Treasury direction expressly states that that agreement can subsequently be varied, because this is a recognition that you might well find that you've got a fluctuation in the amount of work you need as you start to bring employees back to work and as your business reopens and gets back up to speed. It's also quite helpful that the Treasury direction confirms that this agreement you make with an employee when you send it out in writing can be made or confirmed in writing, which essentially means that you don't have to get an employee to send back a written confirmation of the agreement to say that they've agreed in writing. But just a little caveat at that, there's a little bit of inconsistency between this and the draft in the HMRC guidance on the point. But actually, in any event, I think I've been recommending to our member companies certainly that where they can get a written response, a written confirmation from an employee that they've received the furlough letter from you, that's a better position to be in for your own records, and so you can evidence the agreement and the change in the contract. I think where you may be less inclined to focus on getting back the letter you've sent out with a signature or a confirmation on it is if you're varying hours in an existing flexible furlough agreement. So you've already agreed with the employee that they're going to come back to work on a part-time basis, but you're wanting to alter those hours. So though you still need to agree that change with employees, and confirm in writing, just for timing reasons, you may find it easier not to go through the process of getting that agreement back in those circumstances. And notice well that last sub-bullet point about retention periods, you need to retain the written confirmation of the flexible furlough agreement until at least the 30th of June 2025. Now, Make UK have produced a template flexible furlough letter which you can download for free on our website. And you can use that to confirm the employee's agreement to move on to flexible furlough, but it's also suitable for employees who are currently on full furlough, or for those who have previously been on furlough and are currently working, but you're wanting to reduce their hours. And we've also got various other template furlough letters which cover different situations, not just flexible furlough situations. So moving on now to the NHS Test and Trace service. Now, understandably, you're going to be concerned to do the right thing if an employee who's been at work tests positive. And when that happens, that person clearly needs to self-isolate for at least 7 days from the onset of symptoms or until they're well. But what I'm looking at on this slide is what happens in relation to the rest of your workforce when you have one employee who's been in the workplace who's tested positive. Now, if that person is tested positive, has spent time in close proximity with other colleagues, first off, those colleagues don't need to self-isolate unless they're advised to do so by the NHS Test and Trace programme or they develop symptoms. But they should be advised by you to avoid high-risk individuals and take care in practicing social distancing and good hand hygiene and watching out for symptoms. If those employees are then contacted by the Test and Trace service and asked to self-isolate for 14 days, that will be because they've been in direct contact with an infected person or within 2 meters of an infected person for more than 15 minutes. And it is possible that might mean that you've got clusters within your workplace where groups of people have worked closely together who are asked to self-isolate. And if that's the case, what you need to do is to allow a person to work at home if they can, and if they can't, place them on sick leave, and they will be entitled to SSP and possibly company sick pay if you have a company sick pay scheme. I know that quite a lot of our member companies who, if they're a company who only offers SSP to certain groups of individuals, are considering allowing employees to take paid holiday instead of moving on to SSP for the 2 weeks of self-isolation, just to help employees to, manage the otherwise, financial impact of self-isolation. And if you're worried about workers, particularly if you pay company sick pay, saying that they've been contacted by Test and Trace when they haven't, it's just handy to know that they can obtain an isolation note from the NHS Test and Trace service of evidence of the requirement to self-isolate, and you're entitled to ask for that. So as to whether you should keep your workforce more generally informed about confirmed COVID-19 cases, well, the answer to that is yes, you do have an obligation, because you've got an obligation to ensure the health and safety of your employees and a duty of care towards them. So you should be telling your workforce more generally when there's been a confirmed virus case within the workforce if they've been in the workplace. But just be a bit careful, because the Information Commissioner's Office has stated that employers don't need to name individuals and that you shouldn't really provide more information than necessary. So even though you can say something along the lines of, cases of COVID-19 have been found within the workplace, be cautious about giving further details about exactly who it is who's tested positive. The last point on this slide is really just a reminder that if there's more than one case of COVID-19 associated with your workplace, you should contact your local health protection team to support that suspected outbreak. And also, there is government guidance on how to clean and decontaminate your workplace if that happens. So the last issue that I'm going to look at is whether shielders can now return to the workplace, because as you know, there's been a bit of a relaxation in some of the rules relating to shielding individuals. As you know, a shielder is an individual who's considered clinically extremely vulnerable and is somebody who will have received an NHS letter asking them to shield. Now, currently, shielders have been told not to work outside the home, so they can carry on working if they can work at home, but not to work outside the home. But from 1st of August, the government plans that shielders will be able to work outside the home, provided their workplace is COVID secure. So I think another way of thinking of this is that shielders from the 1st of August will be treated in the same way as you currently need to treat vulnerable employees. They can work outside the home so long as the working environment is safe enough. But before they can return to work, you're obviously going to need to undertake a really thorough risk assessment, which takes into account the fact that the individual is clinically extremely vulnerable. And so you should really be looking at giving them the safest possible role and positioning, etc., within your workplace that you can. And we've got lots of information about risk assessments in the FAQs on our website. On top of that, don't forget about reasonable adjustments to enable individuals who are shielding to return to work, because this group of employees are likely to meet the definition of being disabled under the Equality Act. Also, if you can't make someone's usual role COVID secure, have a think about whether you can alter some of their duties or whether there's an alternative role you can offer them. And actually, you might even be able to use flexible furlough. So in the case of a shield, being able to carry out some of their role, but not all of it, so that they work for part of the week, but not the rest of the week. Now, it's not going to be the case that every shielder will be able to return to work, because not every employer will be able to offer every shielder a safe enough environment. And if you find you're in that situation, even with adjustments and even with looking at, you know, alterations to roles and so on, it's really important that you don't allow a return to work, even if the shielder is really keen to come back. And this is really because you've got this overriding duty to look after their health and safety. But this puts you in, you know, a difficult position. But I think that the best option is likely to be, if it's not safe for a shielder to come back according to your risk assessment, the best option is likely to be to keep that shielding employee on furlough until the end of October. If they're eligible to furlough, they probably, most of your shielders, I assume, will have already been on furlough. So although the furlough costs are going up in the next few months, I'd say that the alternatives to furloughing will be a lot less attractive to an employer and to the employee, or both, than keeping them on furlough. And it's also worth noting that we don't yet know if SSP will continue to be available for shielders after the 1st of August if they can't come back to work. And the final point on this slide is about dialogue. Now, it's understandable, isn't it, that shielding employees will have a lot of concerns about returning to work. But equally, as I've mentioned earlier, it's really important not to assume that a shielder will prefer to stay at home on furlough rather than risk coming back to work. So what I'd really recommend is leaving enough time before you want to have a shielder back in the workplace to make sure that you can have a really constructive dialogue with that person, to tell them about your plans, so you can explain what measures you've taken to keep the workplace safe for them, and you can properly listen to any concerns they've got and deal with those concerns appropriately and sensitively. Now, at this point, I'm going to hand you over to my colleague, Tim Thomas, who's going to talk to you about quarantine.
Excellent. Thanks, thanks, Charlotte, for that. Tim, okay, I'll make you presenter now, and you should be able to pick up the baton here with your slide deck. Just before you start, Tim, and while you get those slides ready, I know there's a lot of information there that Charlotte mentioned, and I think I posted in the chat box there, but just a reminder to visit FAQ section of our website, which has got pretty comprehensive content around COVID-19 FAQs from a sort of employment law perspective. So look, Tim, I can see your slides are up now, so without further ado, I'll hand you over to Tim for the second part of today's presentation.
Thank you, Roger. Thank you, Charlotte. Welcome to everyone. Before I start, just a few words of what we're doing at Make UK to help you on the policy front. So we have good connections with government, all parts of government. We raise issues that our members and affiliates have brought to our attention to make sure that we can get some derogations from government, some change to policy. So as we go through, I'll point those out. A couple of things that are worth saying at the moment. So we're speaking to BAYS today, that's the business department, about some further clarification on those new furlough rules that Charlotte was just talking about, to make sure that our members understand them. Can you make people redundant whilst on furlough, after you furlough them, etc. So some slack in the rules there that we're hoping that we can bottom out. Quarantine rules, I'll go on to explain in a minute. We're going back to government to ask for some changes on that too. Test and trace as well. Always worth keeping an eye on that. Charlotte's taking you through the headlines. But on test and trace, you might have seen in the news, lots of chatter from government looking to change and amend the test and trace rules, because this is very much work in progress. So always keep an eye on our coronavirus hub, on our FAQs. They'll be updated in real time as and when there are any changes, and rest assured we're working with government to make sure these rules are as business supportive and friendly as they can possibly be. So without further ado, I'm going to go on to the quarantine rules and give you a quick look through what's happening, what they mean for you, and a pointer for where we think they may go in the future. So, travel restrictions for UK visitors, imposed by regulation, not guidance. They have therefore the force of law. Cover international travellers arriving in England. These regs only cover England, not Wales, Scotland and Northern Ireland, because health is of course a devolved matter. So you have Public Health England dealing with England, and then equivalent organisations and the rest of the home nations that have the force of regulation to decide what they do there. So this is England only. So from June 20, just past, all arrivals outside the common travel area, explain what those in a minute, will be required to complete an online locate form and provide contact and travel details and address for self-isolation. What's the common travel area? Some of you might know. This is the area between the United Kingdom and the Republic of Ireland, where broadly it's a mini Schengen area where we allow people to travel freely without immigration control. And that essentially is why you can cross the border between Northern Ireland and the Republic and not notice any difference whatsoever. So these rules apply to those arriving from outside the city. Okay, so where travellers can't self-isolate in their own accommodation, government will help them find accommodation, not pay for it. That's at their own expense. Those arriving from the CTA, Isle of Man and Channel Islands who entered those jurisdictions from an overseas location within 14 days of travel will also have to self-isolate. Let's just break that down quickly. Isle of Man, Channel Islands, CTA, common travelling with Ireland. If, for example, you've arrived in the Channel Islands and from outside the UK or outside England, and then you come into the UK, but you've only spent 7 days in the Channel Islands, then you're also required to self-isolate. It's a public health matter. The idea is that this therefore prevents people from coming into England from the Channel Islands and bringing with them coronaviruses. All measures subject to review, as you'll see. Penalties failure to comply, they're on the basis of an increase to go from 1,000 to 3,200, and failure to complete notification before you come also carries with it a penalty that you can see on that slide. So what you see now is a screenshot. The screenshot shows how you go about finding more information about these restrictions and what you need to comply. Make UK, we're a member of a pan-European organisation called CMET. We've got lots of good contacts throughout the European Union. So some of our German colleagues have already been in touch saying some of their members are sending workers into the UK. What are the restrictions and what do they need to do? So we always make sure that we share information through our network, our very strong network of EU comparative organisations. Now, there are a series of exemptions to these quarantine restrictions. Now, the most important one I put on the screen there are others, I'll come on to those in a moment. So if you're coming to the UK and you've got specialist technical skills required for essential or emergency works or providing services, and that's including, not exclusively, commissioning, maintenance, etc., to ensure continued production, then you don't need to self-isolate. That's quite a long exemption, and we've gone back to government to say, essentially, how are you breaking it down? What does it mean? Now, government's taking quite a flexible approach to that particular exemption. So it's possible to read it that these workers are only exempted from self-isolation, from quarantine, if they're ensured continued production, not new production. However, the feedback from government is this is an expansive interpretation of this particular exemption. So if there are workers coming to the UK that you know of, and they are installing, commissioning, etc., plant and equipment that a business might have ordered before coronavirus, then they would be exempt from the requirement for self-isolation, providing they complete that passenger locator form that is available by the screenshot you saw before. They also get a letter from the company going to work for showing their personal details, name, address, contact details of the employer, of the business that they're completing the work for, and the work that they will be doing. Essentially, that's a letter of introduction. Some of you might be familiar with these sorts of letters because certainly some members have been writing those for some time for inbound visitors in terms of visitors that need perhaps a visa or a work permit. If you've got photo ID, you need to bring that with you as well. Everyone coming into the UK will have a passport or national identification card if you're coming from the European Union. And you also need to show your travel to the UK is essential for the work. So essentially what you can do is wrap all that in one letter, together with a consignment note to operator's license if you're in the transport sector. So a little bit of red tape there to make sure that you comply with the exemption. But all the details there are on the website, the screenshot of which I showed you a few seconds ago. So Moving on, some other exemptions that might be of importance or relevance to you that you might want to look at. I'm not going to go through the detail, it's on the slides. And Roger, can we make sure that we circulate the slides to all our delegates afterwards, and also a link to this webinar recording? But I will go through the bullet points that are highlighted in bold. So I picked these out, pardon me, simply because I think they might be relevant to you, and we know from feedback to many members that they certainly are asking about this at the moment. So exemptions. People live in the UK but work in another country and travel essentially weekly. Frontier workers, we call those, outbound from the UK to, for example, the European Union. The other one is the exact mirror opposite. So you live outside the UK but come to work in the UK at least once a week. A frontier worker, for example, that might live in France but works regularly in the UK. And the last one, drivers of goods vehicles or public service vehicles or community license holders. So essentially this is aimed at the transport sector to make sure that the free flow and inbound movement of goods can continue without the need to quarantine. So just a few there that you'll see. Some restrictions in terms of how you take advantage of these in each case. So for example, the requirement to show how you're travelling and prove that. But those might be relevant to some colleagues on the call. Some other exemptions. So there are exemptions specifically for the water and sewage sector, essential emergency works, the rail network, specialist skills in the waste sector, specialist skills in oil and gas and electricity generation as well, and also specialist aerospace engineers. So some other exemptions there that might be relevant. The one I went through first, the workers with technical skills coming in, that probably is the most expansive one and the one that is likely to provide the greatest support to manufacturers. Air corridors. So many UK members have fed back to us that these restrictions are causing them difficulties. We've been calling for a relaxation of these quarantine rules as a matter of urgency because they're causing significant damage to exports and customer interaction. So a recent survey showed that 2/5 of companies say the rules have interacted and affect badly their business. 24% said they've lost business. A third of companies say they've impacted the ability to visit new customers, particularly in the European Union. That's the one that comes up most often. A third say it's affected their ability to visit existing customers. So we're calling for air corridors with other EU member states that negate the need of quarantine. And that's the idea that the UK indicates that there are certain member states that perhaps have quarantine rules in place or have had them for some time, that there's a low incidence of COVID-19, and that these are destinations where there is a lower risk of COVID-19 being transmitted by people coming into the UK. Now, the government's indicated a certain warmness to include these in a new scheme, and they might change the scheme, but these are likely to be subject to some restrictions, notably some testing regimes, some testing requirements before these people actually travel to the UK. A word about risk assessments, moving on to health and safety now. So the 1999 Health and Safety at Work regulations require every employer and self-employed person to make a suitable and sufficient risk assessment for employees and other local visitors, and put in place suitable control measures. There's 5 or more employees, and this applies to therefore slightly larger businesses. Significant findings in persons especially at risk must be recorded. So we just spoke to Charlotte about, for example, shielding and the changes to shielding. That could be something that you need to take into account. And what we have on the slide here is a specific matrix for how you would conduct that risk assessment. And the UK has been doing a lot of work with the Health and Safety Executive. Roger shared a link to our coronavirus hub. You will see a large amount of information on there if you need help with risk assessment, or a member does, and also what you need to do with that risk assessment. So lots of talk in terms of risk assessments, whether you need to publish them. There's no legal requirement to publish. However, our Coronavirus Hub Health and Safety Guidance will take you through how you should conduct that risk assessment and how you should share it with your workforce to make sure that they have confidence that the employees conducted the exercise correctly, and to make sure that everyone knows it is safe to return to the workplace. So at that point, Roger, I think we're on to how we can help. Shall I pass back?
Please, Tim, thanks for that. Okay, thanks, Charlotte. Thanks, Tim. Lots of information there, lots of food for thought, no doubt. And we've got some time for questions, so please feel free to send them through. Tim, I think specifically there's a number of questions that have come through, and I've sort of sent them in the chat box. Have a look at those while I just go through this slide here. People on the webinar. So a reminder of how we can help. Both Charlotte and Tim have mentioned this throughout their sort of presentation, but there is a coronavirus hub on our website. The address at the bottom of that slide, makeuk.org/coronavirus, and I've posted that in the chat box too. But that's really a good one-stop shop for lots of the resources and guides, webinars, template letters that our employment law team have been busy updating over the last few weeks and months. I'd keep an eye out in particular for the free template letters, which have proved really useful, and also the webinar series as well. So some free, some chargeable, but there's a good mix of webinar support in there as well. And look out for dates and how to book, or again via that sort of coronavirus hub. Tim, if you just skip the slide forward one more, I think there's a second slide on this one.
Apologies now, gents. Just move that forward. There we go.
Excellent, excellent. Thanks, Tim. Okay, and yes, how can I forget about this? But also some training modules delivered virtually via some sort of clever whiz technology there, including employee rep training, guides, letters, forms, checklists for members in the HR and legal resources section of our site. And also, of course, our HR subscription members can access the HR and employment law helpline on a subscription basis. And again, there's a contact address there, covid19.inquiries@makeuk.org. If you do wish to feed in or get involved in some of the work that Tim has mentioned there about conversation with government on how sort of supporting the manufacturing sector, really. Okay, thanks for that. That's just the sort of the how we can help part. We've got some questions, as I said, which have come in. I'll just go through those questions now. Charlotte, it's probably been a long time since we hear food from you, so perhaps I think if I can bring you back on, if that's okay. Okay, there's a question which I think is applicable for yourself. We're making some redundancies. Okay, so we're making some redundancies for employees on furlough, and someone's asking here: is it legitimate to claim for notice pay under the furlough scheme?
No, thanks for that, Roger. Well, I suspect the person who's asked that question has probably seen some of the reports about the Treasury direction changes, which came out on Friday. Because I think if you'd asked me that a week ago or last week, I would have said quite a straightforward yes, because the HMRC guidance expressly allows redundancies to be made while someone's on furlough, and the references within the old HMRC guidance about avoiding redundancies have gone. But actually, there's just a little bit of uncertainty has been injected into that by the recent Treasury direction, which talks, I think, about the purpose of the furlough scheme being to enable an employer to continue the employment of employees in respect of whom they're making a claim under the scheme. This is something we're a bit concerned about, and I know that it's one of the main topics that Tim is going to be talking to Bays about in a phone call this afternoon, because we really need some clarity about whether or not employers will be able to continue as we currently thought they were to claim under the furlough scheme once people have been put on notice for redundancy. So I'd say for now, continue to assume you can claim during the notice period, but watch this space. We'll update our FAQs and let members know about any developments and hopefully clear up this slight uncertainty.
Okay, no, I appreciate that. Thanks, Charlotte. Sounds like there's breaking developments there too. Whilst we've got you as well, perhaps another one. Is it the case that they simply switch employees on and off furlough and flexible furlough as demand fluctuates?
Well, from tomorrow, yes. I think that's the easy answer is yes. But just I suppose a few things to watch out for. You need to make sure that the employees you're switching on and off furlough are eligible for furlough, so that they were furloughed for 3 weeks consecutively before the 30th of June, or they fell within one of those exceptions, returning from maternity leave. You are going to need to have agreed with them about the changes with the employee and confirm that agreement in writing. But actually, I think the one thing to really think about, particularly if the pay and hours arrangements are quite complicated, are you need to think about talking to your payroll department about how frequently it's feasible to move people in and out of different working hours and different working patterns, because the calculations can be quite complicated. And I think your payroll department might, well, you might not be too popular with them if you chop and change too much, because just working out how much to pay the individuals and how much to claim for under the scheme may be a bit complicated. But the headline answer is yes, you can if you follow the right methods.
Okay, thanks Charlotte. No, I appreciate that. Tim, I don't think we should let you off too lightly either. There's a couple of questions come in here. If I can just bring you back on, and if I can indeed find the question that was posed, just bear with me. Okay, Tim, what's the situation where we need to send one of our employees to somewhere in Europe to perform a commissioning of a system and then return to the UK? Do they need to quarantine?
Roger, a frequent question we've had from our members here. Simple answer is this, and we've raised this with government. If they come back into the UK and they're going to fit within the first exception that I ran through, especially this is the essential technical skills. So if they come in to do some work and you can fit them in an exemption, no, they do not need to quarantine. However, feedback from members is that very often someone will go to the EU 10 days, 14 days, come back to the UK, and then they're on rest days. That's trickier. Then they would need to quarantine. And that's what we've been feeding back to government to try and find a way through that. I think the answer, Roger, is try and fit that person returning back into that first exemption that I gave you. If they cannot, they need to quarantine. Thirdly, look out for the Make UK website. So call again, Charlotte's referred to with the business department today. We again raise it. We fed back exemptions from members. The only way, if they're not going to fit within that first exemption and you don't want to quarantine, is to follow the Make UK website, and we will let you know if we're successful in seeking a derogation, some flexibility in these rules to make sure that they don't need to quarantine for 14 days. The answer, Roger, is to be the air corridors I referred everyone to.
Okay. No, thanks, Tim. Appreciate that. Okay, there's another one here for you, Tim, I think. Okay, question for Tim. Do the same rules apply if members are travelling to the Channel Islands or CTA, presumably it's a common travel area, or can you advise if these rules apply if you are outbound into the CTA?
So outbound to the common travel area, these rules only apply in England. So if you're outbound to the common travel area going to the Republic of Ireland, you'll need to check whatever the rules on the Republic of Ireland on quarantine. In practice, I cover this. The CTA is essentially the Schengen area, so there is essentially free movement. Policing that, restricting that, is likely to be quite tricky. So whatever they do in Ireland, that is likely to be a matter for the Irish, but also there's likely to be some quite free movement between the UK and Ireland throughout this period of time. Inbound, of course, in the CTA, then, of course, as I indicate, you're exempt unless you landed in the common travel area, Republic of Ireland, within 14 days of your onward travel to England. Just to labour one point, these are English-only rules, so not advising anyone to do this, but it might have occurred to everyone on the call that, of course, if you travelled to Scotland, then you'd be subject to a different set of rules, and onward travel between Scotland and England then, of course, would be an entirely separate matter.
Excellent. Thanks, Tim. I think I'm looking one eye on the clock here and the conscious of everyone's time, but it's probably, if I squeeze one more in, if that's okay. Tim, again, this is probably for you, but if I said, apologies, I've lost the question. What should I tell EU visitors coming to the UK to work for me?
Right, Roger, that's an easy one. Look at the screenshot that we had during the presentation. We'll circulate the slides. They must comply probably with the first exemption, and that means providing the letter of introduction from the employer firm in Germany and also the letter of introduction from the client firm in the UK, providing you fit within that particular exemption.
Okay. Excellent. Thanks, Tim, for that. I can see there's a couple of questions that have come in, are probably of a technical nature, probably require more time than we've got left on this session. So apologies. We'll certainly do our best to come back to those questions. But look, that just leaves me all about time to say thanks everyone for dialing in and attending this session. Thanks especially to members of Make UK's partner organisations who've joined us for today's session, and thanks Charlotte and thanks Tim for your time. Much appreciated. So good afternoon everyone, and enjoy the rest of the day. Thank you.